Okay. All right, we're on the record in 24-15875, the state of Mississippi versus Carly Madison Gregg. We have several things that we need to discuss concerning Ms. Gregg today, that we have to cover with Ms. Gregg today. You're Mr. Coleman. Sit down, Mr. Coleman. You're going to be a minute. First thing I want to cover, and you can speak to me from seating right there, Mr. Coleman, is MEC 49 and MEC 50 as it relates to Ms. Gregg, or the orders for mental evaluation. Have you had a chance to review those?
No, sir, we have not. But our retained medical doctors have informed us that they are unable to complete their mental evaluations and testing until Carly is released from jail.
All right, well, that's not going to be necessarily true. All right, so here's the way we can do that. And I understand that that's one of the concerns, and it's certainly a concern, but we got two different things going on here. So I'm going to address what you said first, then I'm going to come back to the Mississippi State Hospital. She can be either evaluated in the jail, or if your psychiatrist or psychologist believes that she needs to come to his office, she can be transported by the court staff and deputy to his office for any evaluations. So her detention or incarceration will not prevent her from being evaluated. So if you're sincere about wanting her evaluated by someone of your own choosing, then you need to make yourself available for that, because as they say, the dog won't hunt going forward, because we will accommodate her being evaluated by your expert. Now, the second thing is the orders MEC 49 and 50. I want you to go back and look at those today, because both of those, MEC 49 is the order for mental evaluation for competence to stand trial. And the second page of that order specifically requires the defense counsel to promptly prepare and furnish to the examining mental health expert the following. Now, I understand he hadn't had a chance, and I understand you don't have a report, but there are other things there that you can provide to the mental health facility at the Mississippi State Hospital. And then once you do that, you're required by order of the court to file a certificate of compliance that you have done that. So both MEC 49 for the competence to stand trial and MEC 50, the supplemental order for McNaughton analysis, both have affirmative requirements for the defense counsel to provide information to the state hospital and to file certificates of completion. The state hospital can't begin until you've done that. The state of Mississippi has already done that. They've sent their material there, they filed their certificate. Is there any reason, Mr. Coleman, that you can't get this filed in the next 24 hours?
I would have to speak to Carly's medical examiners, Your Honor. I'm not aware of their schedules. I'm not aware of their availability. Certainly, I'm willing to reach out to them and see if we can expedite that process.
All right, my patience is going to be a little thin, Mr. Coleman. The order says 10 business days from the date of the order. April the 18th was when the order was entered. So we've run out of 10 business days since the entry of the order, and this is obviously a most serious event. And while you certainly have a right to have a mental evaluation done, the state of Mississippi has a right to have the state hospital perform one as well. And I'm not going to allow you to obstruct that process. I'm not accusing you of obstruction. I'm just telling you right now we have non-compliance with my orders, all right? Today's Tuesday. I'm going to review this next Tuesday, Mr. Coleman, and I expect when I pull up MEC to find certificate of compliance for both MEC 49 and MEC 50 that says that to the best of your ability you have complied with the orders of this court. Now, if you have not provided those by next Tuesday, then I'm just going to be dead up honest with you. I'm going to have a show cause hearing. I'm serious as I can be about this. This is a serious matter. I need your cooperation. I will have your cooperation, whether you cooperate or I have to make you. I'm not trying to be ugly. I'm just trying to tell you how serious this is, okay?
Understood, Your Honor.
Okay. All right. That's fair enough. All right. Now then, let's move on to the two motions that the defense has filed. We got two items on the agenda of the docket today. One is MEC 53, which is a motion to reduce bond filed by the defendants on this past Friday, May 10th. That was MEC 53, and a motion to exclude the public and the media, which is MEC 56. According to the Mississippi Rules of Criminal Procedure 1.3D, it states that a written motion and notice of the hearing thereof shall be served no later than 5 days before the time fixed for the hearing. The notice of hearing for both motions was today. The motion to exclude the public and the media was filed yesterday, the 13th. We clearly are not within the, we've not had the requisite time here. Mississippi Rules of Criminal Procedure 1.3A specify that when the period of time prescribed or allowed is less than 7 days, which is what we have here, that Saturdays and Sundays don't count. So and we don't count the day of the filing, but if I did count the day of the filing for MEC 53, which is the motion to reduce bond, then we've only got 3 days. If I count the day of filing yesterday, which I'm not supposed to, but if I did, for the motion to deny access to the public or the press, then I've got 1 day on that clock. So, all that to be said, Mr. Coleman, the rules of criminal procedure have not been followed as it relates to notice on those two motions. That can be cured by the state of Mississippi if they choose to waive time in this event. Mr. Berry, what's the state's position on these two motions?
Your Honor, as to the motion to reduce bond, I spoke to Mr. Coleman beforehand and tried to talk to him about that, and the state does not choose to waive that at this point. And generally, when we choose not to waive that at this point, it's motion to exclude the media and the public. Your Honor, we defer to the court on that, as for this motion.
Okay. Well, and I tell people all the time that it's a lot easier for me if I just follow the rules. And they're, like everything else, we have a lot of rules as it relates to criminal process. And I've just been quoting the rules of criminal procedure as they relate to motions and notice. But also there is a set of rules, oddly enough, for the Mississippi Rules for Electronic and Photographic Coverage of Judicial Proceedings, which our media does a good job of complying with. I've not had any objections or any complaints regarding the media whose willingness or want to be here. They do provide their notice as they are required. I honestly believe that the public has a right to know this is a public forum. These are public courtrooms, barring specific problems, and I'm not ruling on the motion because the state's not waiving time, so it's not properly before me. But I just say that, I say all that to say that the rules for electronic and photographic coverage of judicial proceedings, Rule 7, which the defense has complied with, says any party may object to electronic coverage by written motion, which the defense has done, which was filed yesterday. And it says such motion shall be filed no later than 15 days prior to commencement of the judicial proceedings unless good cause exists to shorten the time for filing. So what we'll do, I know the media is an interested party here as well, who would probably object to any closing of any judicial proceedings as it relates to Ms. Gregg. So the rule requires at least 15 days out there. So we can do it, Mr. Coleman, however you want to. You got two motions. The motion to exclude the media, I won't hear until 2 weeks from today. I'm going to give them 15 days and get what the rule says. The second one, the motion to reduce bond, you will certainly have met that time requirement by next Tuesday. So it really, if you want to hear the motion to deny bond next Tuesday, it kind of renders your other motion moot, because we will not have heard the motion to exclude the public and the media. Now, if you want me to hear that one first, then I'm going to need to hear both of them 2 weeks from today. So what's your choice?
Understood. Your Honor, we believe that the media should be excluded. We believe that Carly's being prejudiced by the media. We believe that it's in her best interest to exclude them first, potentially, and then have our bond hearing.
Fair enough. Fair enough.
But one more thing, Your Honor, I understand that the rules are the rules, but Carly is also entitled to a bond hearing every 30 days, correct?
Well, she's had one, and she's entitled to bond. And I'm going to be pretty open about those things. Whether something has. And my first thought was when I saw your motion file, my first thought was, what's different? And it won't do any good to come back. And I know you didn't argue the previous motion, but But if there's not any new information, we're kind of wasting everybody's time. So I assume that when you bring forth a new motion, and I'm not going to restrict you, Mr. Coleman, on, I mean, we can hear it as many times as you want to present them if we have new information. Now, we're not going to beat the dead horse if, nothing new has happened since the last hearing. But I'm open. The bottom line is I'm open to hearing any motion you have. So I hear what you're saying on the motion to exclude the media and the press first. So what we'll do is we'll continue both these motions to 2 weeks from today. We will hear the motion to exclude the media and the press first. Then I will rule on that, and then we'll deal with the motion to deny bond. I will tell you, though, Mr. Coleman, that the default position, of course, by the Supreme Court is to favor the media and the public. That's the default position. Momentum begins against you in that event, so you'll need to make a compelling argument for the court to determine that the public and or the media is not entitled to participate or to observe the proceedings as they relate to Ms. Gregg. So anything else at this point, Mr. Coleman?
No, Your Honor.
Mr. Barry?
No, sir, Your Honor.
Okay. All right. And Mr. Coleman is, I know, I want to point out a couple things further, just so everybody knows. I know the case with Ms. Gregg has generated a lot of attention, but I want to, and I know being a juvenile creates more attention here, and I am sensitive to that. And I know the last time we were here, the family had an opportunity to visit with Ms. Gregg. I'll extend the same opportunity again, family. If y'all want to visit with Ms. Gregg, we'll do the same thing we did last time. Just go back to the jail and they will accommodate you there. It's also my understanding that Ms. Gregg has access to an electronic pad that she's able to make phone calls with, FaceTime with. There are no restrictions on her use of that pad. I understand that they have a time limit of 15 minutes per call, but I understand that once you time out on that call, she can place an immediate call right behind that. So it's my understanding that she's either, as of yesterday, I think she had used that pad 36 or 37 times and had one physical visit. So I am sensitive to what's going on here, but I do know that we try to accommodate her and the other juveniles with access to these communication pads so that she can communicate with her family. All that being said, that we'll go ahead and pause this hearing now. We'll take a short recess to let me swap out defendants here for a moment and return Ms. Gregg. And family, if y'all want to make your way back to the jail, then you'll be able to visit with Ms. Gregg at that point. All right, we'll be in recess for about 10 minutes.
Mr. Coleman.
Okay.
2 weeks of the holiday.
Okay. Well, just tell me.
Yeah, I got it.
Okay.